All right, in our next session, we have a really august panel of historians here today with us, who were a part of putting the amicus brief together. So they're one of the voices that the U.S. Supreme Court will be hearing as they consider Alexander versus South Carolina NAACP. So I'm going to call on each one and ask you to introduce yourself briefly, and then we'll go into the discussion. So we'll start with Dr. Burton. All right, tell us right quick who you are.
I'm Vernon Burton. I am the Judge Matthew J. Perry Distinguished Professor of History at Clemson. Spent most of my career at the University of Illinois, 34 years, retired there, and have come back home. I grew up in 96, South Carolina.
Welcome. Thank you. Dr. Carter.
I'm a retired historian, spent, like Vernon, most of my career, not at Illinois, but at Emory University in Atlanta. But from 2000 to 2007, I taught at the University of South Carolina, where I graduated as an undergraduate. And like Vernon, my specialty is Southern history, African American history.
Yes, thank you. Thank you for joining us. Dr. Harris.
Hi, my name is Carmen Harris. I'm a professor of history at USC Upstate, a native of Gaffney, South Carolina, and my specialties are Southern agricultural history and African American history and South Carolina history.
Thank you. Thank you so much for being here. And Dr. Venters.
Hey, I'm Louis Venters. I'm a professor of history at Francis Marion University in Florence, which is the city of my birth by chance. And I teach South Carolina history, African American history, public history, and also supervise our history internship and our public history and archaeology track.
Okay, thank you. Thank you one and all for being here. And I'd like to start by asking, why historians? Because I saw a list of amicus briefs that are about 15 deep, and I saw from historians there. So who can tell me why historians wanted to come together and to be a part of producing an amicus brief in this case?
Well, let me start here since I'm maybe leaving. Everybody knows William Faulkner's statement that the past is the present is sorry. Stop here. Sorry, I've had a long
the past
day
is
today.
prologue. Is that it?
The past is very much a part of the present. And you can't really look at what's going on right now and assume that things miraculously changed in 1964 simply by the passage of the Civil Rights Act. Cultural, historical patterns run very deep, and we know that no matter what the law has changed, that there are patterns that continue to affect particularly in this case, voting rights for African Americans.
Okay, Lewis, what do you say?
Well, I wasn't part of originating this particular brief, but when the opportunity came to me, I jumped on it for a number of reasons. As a professional historian, I mean, part of what I studied and part of what I teach is about the complex interactions between race and politics in American history and in South Carolina history. And so it seems like just as a matter of conscience, you know, to be true to my profession, it's important to put my name when I can on any effort to clarify the history of race and politics in our state and in our society. One of the things that personally set me on the path to accepting the chance to sign on to this brief when it came to me was really, it's closely related. It's the the Shelby County versus Holder decision from 2013 that took away the most important provision of the Voting Rights Act of 1965. And I remember, 10 years ago now, learning about the Shelby County decision, and as a historian, what I heard was the basic argument of the state of Alabama was, look at the great Black voter participation that we have in Alabama. You see, we don't discriminate. We don't need preclearance anymore. And of course, preclearance, that provision of the Voting Rights Act, is precisely why there was good Black voter participation in Alabama. So what I recall from that case was a misuse of history, what seemed to me to be a willful, not just blindness to history, but a misapplication of history on purpose, muddying the waters to try and advance a spurious argument. So historians help this country to know itself, and we have to speak out, especially when it's very much in line with our teaching and our scholarship. This seemed like an important thing for me.
That's so connected to what we're talking about, making sure that people understand and have a right application of history.
Yeah.
Dr. Harris, what are some of your thoughts?
So, like Dr. Ventnor's, I did not develop the petition, didn't participate in it, but very much think that historians have an important role to play. This is the second time I've actually signed a petition. I signed the one in, I believe it was like 2000 on the Confederate flag. I was a young scholar at that time. But, when I think back, when we look at Briggs v. Elliott and Brown v. Board of Education, historians were involved in that. C. Van Woodward and John Hope Franklin, both of whom I had the pleasure of meeting briefly, were part of that team that developed the historical argument around that case that destroyed Plessy versus Ferguson. So our knowledge essentially is our power.
That's right. Thank you so much. And Dr. Burton, what are your thoughts on that?
Well, a lot of thoughts. First, I guess I am partly responsible. The LDF in NAACP reached out to Morgan Kaiser and me and asked us to be the consultants with the attorneys. Now, they did not take all of our arguments, and Dan Carter and I, who served in the Charleston case, probably knows the one that we argued very strongly that should be taken. But they, of course, are trying to win the case, and so they want to follow the lines of the argument. That's one of the things you learn as a historian, since I've been doing this since 1980 in Mobile versus Bolden, is that truth itself maybe is not how the law, as Justice Oliver Wendell Holmes says, justice and the law are not the same thing, but we have to speak truth to power. And I do want to say, just briefly, following what Louis said, that's so important, is that in the most notorious, I think almost all historians agree, if not legal scholars, case of all time, the Harriet Dred Scott decision, the lower court judge, before it went to the Supreme Court, argued that things are not as they were, meaning that things have changed. That's almost the exact word that Justice Roberts said with Shelby v. Holder. Things are not as they were. And then in just 2021, Justice Alito, in a notorious case, Baranovich, is actually going after Section 2. And what does he say? Things are not as they were in 1982, referring to when the Voting Rights Act was renewed. And a couple of cases I've done very recently, I sort of shot the attorneys when I said, yes, Justice Alito is right. It's not like 1982. In 1982, everyone agreed people should vote. They were interested in diluting their vote, making sure that minority voters, particularly Black voters, did not have the equal chance to elect people. They weren't trying to stop people from voting. I said, it is like 1898 and Williams versus Mississippi. They're actually trying to stop people from voting now. We have something I never thought would happen, retrogressed in the most important fundamental right, the right to citizenship and the right to vote. and to have an equal opportunity to have your vote count. So I think we're in a crisis in democracy, and what we historians have to do is speak truth to power. And secondly, as Dan was saying earlier, the way the court and laws work now, you have to show as part of the way to win these cases is that there is a history of discrimination. And one of the most amazing things about this brief is how this reflects 1870s and after Reconstruction, that interracial period of democracy, of how Black people were disfranchised then. Even the district itself almost looks exactly like the districts that were drawn at that time by Democrats to pack all of the Black voters they could into one district so that whites could control the other. So it's very important on two levels. One, our moral obligation, and secondly, the legal sort of way that you win these cases through the 14th Amendment or the Voting Rights Act requires that you show these things, basically a totality of circumstances, and one of those, or the intent, both of those is the history of discrimination in voting.
Wow, yes. Well, why don't you tell us a little more about, I think, did somebody want to jump in?
No, I was just going to say that there are many similarities going, as Vernon says, back to the 19th century, but the one absolutely common factor in it is that if you want to disenfranchise people, you can develop all kinds of different kind of techniques, everything from gerrymandering to, I mean, there are dozens of techniques that can be developed. And that is why the pre-clearance provision was there, but so that the Civil Rights Division of the Justice Department could look at it and say, what's the effect of this? Not whether it's technically exactly within the law or not, but what's the effect of this measure that you're adopting, whether it's going from single districts to at-large districts or any of dozens of other things. And by losing that, you end up having, it's like whack-a-mole, because there's, every time you turn around, there's another way to do it. There's another way to limit the right of Americans to vote. And until we get a process by which, I think there's some states experimenting it now, in which you have a process in which everybody's registered to vote almost automatically, and you get access to the ballot box and you end gerrymandering, we're going to continue to have this kind of enormous discrimination by whichever party happens to have the levers of power.
And I want to encourage people, this is the brief. You probably can't see it very well there, but take a look at the maps. If you want to see history repeating itself, the maps are powerful in telling you exactly what happened. And remember, Reconstruction didn't end it all one time. We sort of think about, well, it was 1876, but once you took away one thing and another till one party got complete control, and then they totally disfranchised people.
Yes, well, I want to thank all of you for your work. I want to give everybody a chance to make a final comment if you have a final important point that you want to make. I certainly want people to know if they don't live in Congressional District 1, which is, 4 counties, Charleston, Beaufort, Berkeley, and Dorchester. If you don't live in South Carolina, why do you think this is an important case? So why don't we start with Lewis?
So why is this an important case for everybody in the country? Well, I mean, one way of thinking about it is that, who gets elected to Congress from every state impacts the balance of power in the U.S. House of Representatives. So the way districts are drawn in this state or that state does, in a general sense, have to do with what gets done in Congress and what doesn't get done in Congress. And we're in sort of a catch-22 here, right? So there's actually legislation that's been in Congress for a minute now, the John Lewis Voting Rights Act, that would fix this, the part of Section 5 of the Voting Rights Act that was struck down in 2013. But ironically, you can't get it passed because there are not enough people in the House of Representatives who are inclined to protect voting rights. So ironically, the fact that voting rights are not protected make it possible to not protect voting rights. Does that make sense? I mean, that's really something that affects everybody in the country.
Yes.
And in terms of how it affects everybody in South Carolina, you know, one of the things that I really appreciated about the brief is how comprehensively it laid out, and there's more, but I think it's a very succinct argument that gerrymandering of the congressional districts is part and parcel of a number of techniques at the state level and at the local level that have effectively disfranchised Black voters. So it's not just gerrymandering the congressional districts, but it's also how we look at the state house and state senate representatives districts, and as well school boards and so forth. So there's a number of ways. What the brief does is it establishes patterns of disfranchisement today and for the past 150 years.
Yes, Dr. Harris. Thank you, Dr. Venters.
Well, one thing I can say is probably in the 90s, I can't remember the other thing that just, average African Americans were saying that I'd never believed would happen. One of the things they said was that Black people were going to lose their voting rights in some particular year, and I thought that was crazy. But I stand corrected in that regard. I personally live in a gerrymandered district. I think organically I ought to be in Will Timmons' district because it was mostly Greenville and Spartanburg County. Mm-hmm. I'm in Greenville County, but I'm in a little hook of Greenville County that's somehow in Jeff Duncan's district, and I don't even know why. I moved about 5 miles from where I lived before, and I changed districts. Mm-hmm. And I think the last thing I would say is whether they're Democrats or Republicans, a certain set of white South Carolinians are going to white South Carolina. And by that, I mean they come from a history and a heritage of seeing African Americans as subordinate, not worthy of the vote. And regardless of the fact they've changed their political affiliation, they still have the sensibilities of their ancestors, and they go out of their way to make those sensibilities real in the lives of some people.
Thank you. Thank you very much. Dr. Carter?
Well, I just to emphasize again how extraordinarily complex it is to try to deal with all the various means of limiting the vote of not just minorities, but poor people as well. I mean, we know that in this country, voter fraud is, your chances of experiencing voter fraud are about like being struck by lightning, probably less than that. And yet we know that poor and African Americans are less likely to have photo IDs than whites are. And so when you institute that, you can say, oh, we're just trying to protect the integrity of the voting system because people don't trust it. Well, why don't they trust it? They don't trust it because there was a deliberate campaign to convince people that voter fraud was going on. And that's what I mean about the subtlety and why it's so important to try to engage in a kind of educational program to explain to those people of goodwill, and there are whites of goodwill, that this is not fair. This is not what this country's supposed to be about.
Thank you. Thank you, Dr. Carter. And closing out the historian panel, Dr. Burton.
Well, I'll just echo everything everyone said. And Armand Durfner, great civil rights lawyer, and I did a book, Justice Deferred, Race Supreme, where we go through all of this. And one of the things to reflect what Dan just said, it turned into first a sentence to a whole chapter, a war of words, purpose, intent, and effect. And when it was very clear and people said we are disfranchising Black people, we don't want Black people to vote and believe in white supremacy, then it didn't matter. You had to show effect. Then when you could show effect, and of course they didn't believe it, it's got to be purpose and intent, and made it very, very hard to do. And I want people in South Carolina, speaking to others, we think of ourselves as somehow different than those rednecks down in Georgia, Alabama, Mississippi, because, you know, we had integration with dignity. The only dignity was Judge Perry and Matthew Gann, as far as I can tell. Matthew Perry and Harvey Gann, excuse me. But it was South Carolina who led a nullification in Civil War and the first state to challenge the Voting Rights Act. And even though Judge Roberts ellipsed the most important words when he got rid of Section 5, or really Section 4, the formula, it was not just arbitrary, it was a formula that determined who or which states are covered in this pre-clearance thing. And if those had been left in, it says just the opposite of when he created out of whole fabric this doctrine that has no basis of the equality of states and the sovereignty of states. What Warren said was only when they come into the Union, and it means the opposite. So I think South Carolina, why South Carolina? That's why it's so important. And I must say, every time that we've had these kind of crises, like was Mobile versus Bolden in 1982, or the vote, was always bipartisan. But as Dan Carter has shown better than anyone else in his writing, we are at a crazy state where you cannot separate race and partisanship, I believe. And so it gets even trickier as they play these words games instead of just looking at the effect of which we were talking about here. So it's, to me, once again, back to 1898 and playing with laws that use neutral sounding words. It doesn't say we're disfranchising Black people, but we're disfranchising those who don't have a car, work 8 to 5, or you know, it's very much like the poll tax literacy clauses of the old days. So I think we have to be on our guard. If you care about democracy, I would never tell anyone how to vote, but I think it's important that you understand, and it's our job as historians to educate people on exactly how we got to where we are so they can be wary of the kind of things that are going on now.
Well, I thank all 4 of you for taking the time to join me today as we talk about the Amicus Brief from historians. Thank you for signing on to that and for being a part and for helping the public to understand what the brief is about and why. So Dr. Venters, Dr. Harris, Dr. Carter, and Dr. Burton, thank you all for your time today.
And thank you for letting me see my good friends here on the Zoom screen. It's good to see you all.
All right. Y'all take care.
Take care.
Okay.
And thanks for raising
Bye.
everybody's awareness. Really. Thank you.
Yes.